NACDL is the association of the nation's criminal defense bar.
The United States keeps more of its citizens behind bars than any other country in the world, except for maybe North Korea. And the Harris County Jail is the third largest jail in the United States, which makes it one of the biggest facilities in the world. Now, just seeing the jail that in this picture here, you know, it's a really beautiful building. It's historic. It has nice little balconies with these cute little awnings. It occupies prime real estate right in the heart of downtown Houston, overlooking the beautiful Buffalo Bayou. Most people don't even realize it's the jail. But for those who know, you realize that those are not even windows on this building. Those are smooth, solid walls. And it is a giant fortress. At any given time, the Harris County Jail houses approximately 10,000 people. Of those people, about a third of them are either mentally ill, homeless, or both. In fact, at any given time, the jail is always hovering at, near, or over capacity, to the point where it's not unusual for us to ship our prisoners to other counties, other facilities, usually, often as far as Louisiana. Even our pretrial detainees are kept in jails in Louisiana, just to be bussed back to court every 4 weeks or so, out of reach of their families, out of reach of their lawyers, just because our jail is so overcrowded. In addition to housing, you know, way too many homeless people, mentally ill people, the jail is also racially disparate. Whereas Harris County's population is about 18% African American, the population of the jail is close to half. Adding insult to injury, about 75% of those 10,000 people are awaiting trial. They have not been convicted of anything. They are sitting there under a mere accusation. You know, they have the presumption of innocence. 75% of those folks are too poor to be able to pay money to be released to await trial. In 2017, the Chief Justice of the Texas Supreme Court, who really only hears civil cases, observed, he said, 20 years ago, not quite 1/3 of Texas's jail population was awaiting trial. Now the number is 3/4. He said, liberty is precious to Americans, and any deprivation must be scrutinized. Many who are arrested cannot afford a bail bond and remain in jail awaiting a hearing. Though presumed innocent, they lose their jobs and families and are more likely to reoffend. And if this all weren't bad enough, taxpayers must shoulder the cost, a staggering $1 billion per year. The money bail system is a gross anomaly in the American criminal justice system. People who are arrested essentially face three choices. Number one, get together enough money, scraping the bottom of the barrel, getting contributions from friends and family in order to literally purchase their way out of jail. Two, plead guilty just to get out of jail. Or three, spend weeks or months in custody awaiting trial. In May of 2016, Miranda Lynn O'Donnell, a 22-year-old single mother, was arrested and charged with driving with an invalid driver's license. She was taken to jail where she was informed that she would be released if she paid a secured money bond of $2,500. That was the amount that was set by the Harris County bail schedule. And if she did not either pay that full amount directly to the clerk in that building or a non-refundable premium to a bondsman, then she would be forced to stay in custody. And Ms. O'Donnell was poor at the time. She struggled to meet the basic necessities of life. She received benefits from the Women, Infants, and Children program in order to feed her daughter. She couldn't afford housing expenses, and so she had to stay with a friend. She was working, but she had just started a new job that she had only had for about a week, and she hadn't even received her first paycheck yet. There was no way that she was going to be able to purchase her release from jail. While she was in jail, she was around midnight, so about 7 hours after her arrest, she was interviewed by Pretrial Services. Pretrial Services works for the county. They do a whole financial interview. They find out how poor she is. They see that she's only charged with a very, very low-level misdemeanor that is really comparable to a traffic ticket. And they write a report recommending her for an unsecured personal bond, which would mean that she would be able to get out on her own signature without having to pay any money and just on a promise that she would show up to court. At 7 a.m., after being in custody all night and probably not really sleeping or eating, she appeared by herself without an attorney before a criminal law hearing officer, otherwise known as a magistrate. She appeared before this magistrate who was on a TV in front of her, just like on this picture here. She was standing by herself, staring at a TV screen with a judge in one corner in a little box, a prosecutor in another corner on a little box, and an overview of her own self looking back at her in the top right corner. And she heard these people on television talking about her case. The judge decided that there was probable cause that she was driving with an invalid license, told her not to speak, and said that she was not qualified for a personal bond without any explanation, and told her that her bond was $2,500. When asked if she would hire a lawyer or seek help from a court-appointed lawyer, she responded, seeking help. Those were her only 2 words during her 50-second hearing. So, in May of 2016, Ms. O'Donnell, represented by the Civil Rights Corps, the Texas Fair Defense Project, and a local private Houston firm called Sussman & Godfrey, brought a class action 1983 suit against all of the Harris County judges, the county sheriff, and the county hearing officers, or those magistrates who appear and set people's bail on in PC court, on TV court. She alleged that the county's post-arrest detention policies violated equal protection and the Due Process Clause of the United States Constitution. She was represented by excellent attorneys, particularly Harvard-trained lawyer who had filed several other similar lawsuits all around the country where other jurisdictions had agreed to settle the lawsuit just by agreeing to remedy some of their pretrial bail procedures and reforming their system. However, Harris County dug their heels in and spent millions of dollars hiring private attorneys to defend them in this lawsuit in federal court. In a odd or fortunate confluence of events, in April of 2016, so right at the same time that the O'Donnell lawsuit was getting started, Harris County was also awarded a MacArthur grant. They had applied for this $2 million grant to help to reform their criminal justice system, and they had just found out in April, the month before the O'Donnell suit was filed, that they had been awarded this grant. In characterizing how this $2 million would be spent, District Attorney at the time, Ms. Devin Anderson, stated, "Our main goals are to safely reduce our jail population by 21% in 3 years. That's 1,800 people, and reduce the glaring problem of racial and ethnic disparity within our jail." So this is a glorious goal. They've received this $2 million to implement this project. And they are specifically looking at bail reform with this $2 million. So part of the MacArthur grant money went to developing a new risk assessment tool called the PSA that would evaluate new arrestees on their suitability for personal bonds in order to more scientifically decide who should be released for free, what bonds should be set at, things like that. And with the ultimate goal being of releasing more people from pretrial custody and not keeping them in just because they're poor, and hopefully reduce some of that racial disparity as well. So extensive litigation in the O'Donnell case occurred throughout 2016 at the same time that they're also trying to improve the pretrial bail procedures using that grant money. And so at the same time, the federal district court is hearing a lot of evidence about how the pretrial detention policies have worked throughout the decades. And it turns out that the 52nd hearing that Ms. O'Donnell had, where they told her she wasn't qualified for a personal bond, is very, very typical of how these hearings went for everyone in Harris County over the last few decades. As part of the litigation in the O'Donnell lawsuit, they introduced 2,300 videos of these bail hearings that exposed a great deal of rude and abusive conduct by the judicial officials. Some of these were widely publicized, went on the news. The hearing officer, he says, you know, you're not getting a personal bond. Okay, you're here for trespassing or something very, very minor. And do you want to have a lawyer appointed to your case when you get to court? And she's like, yeah. And he says, what? And she's like, yeah. And he's like, yes or no? Yes or no? And she says, yeah. And he's like, all right, that's it. I'm doubling your bond. It's set at $4,000 right now. Ma'am, you can go with the deputy. And she's like, you said you couldn't hear me. I said, yeah. Yeah. And so he doubled her bond for that. And this is all just totally typical of everything that was going on. And then there was another one where the judge was thinking about giving her a personal bond if she would have somewhere else to stay besides at her mom's house because her mom had kicked her out. That was part of the reading of the probable cause. And so, you know, he's like, ma'am, do you have somewhere else to stay? And she says, no. And he says, all right, that's it. I'm denying your personal bond. And she's like, what is a personal bond? And he's like, man, a personal bond is where you have somewhere else to stay. And she's like, well, I can stay. Man, don't interrupt me. Don't interrupt me. And so he's like, move along. So it's just, there's just tons of that. And that's what, and so it was so bad. Anyways, so some of these 2,300 videos that were played in federal court apparently showed such offensive behavior by the magistrates that State Senator Whitmire actually filed a complaint with the Judicial Conduct Commission, alleging that these Harris County magistrates were being abusive and not following the law. So he filed this complaint in December of 2016. He stated, the total disregard for citizens and the complete lack of judicial temperament and professionalism are unacceptable. He said, I'm requesting a thorough investigation by the State Commission on Judicial Conduct to determine if these violations are intentional, individual, or the responsibility of elected judges who appoint these magistrates. So this was a very unusual step for someone to, especially a senator, to file a grievance like that. So just a few months after that, in April of 2017, federal judge Lee Rosenthal came out with an opinion granting the plaintiff's motion for a preliminary injunction. And in this opinion, she found Harris County's bail system to be unconstitutional. She held that it violated due process and equal protection. She wrote a very detailed and very eloquent opinion that was very highly regarded. It went into a whole lot of detail about how Harris County's bail system works. And she concluded Harris County's policy is to detain indigent misdemeanor defendants before trial, violating equal protection rights against wealth-based discrimination and violating due process protections against pretrial detention without proper procedures or an opportunity to be heard. And she held that they have a consistent and systematic policy and practice of imposing secured money bail as de facto orders of pretrial detention without consideration to what the person can afford, knowing that the people will be kept in jail. She found the testimony of the county judges and the criminal hearing officers to be not credible. She found the testimony of the county judges and the Harris County magistrates to be not credible as to whether they knew that their orders of money bail would actually keep people detained. And so she enacted a very unusual preliminary injunction against the county on May 15th, 2017. She ordered that, number one, people arrested on misdemeanor charges were to be interviewed by pretrial services about their financial conditions and their ability to pay money bail. They're supposed to sign an affidavit swearing as to how much money they could actually afford for bail. A lot of the time that number ended up being 0, but it would vary. After a very detailed financial interview, they would swear and affirm how much they could afford for bail. And all misdemeanor arrestees whose bond was set over that amount, who were not able to pay bail, were to be automatically released on an unsecured bond by the sheriff. So essentially, the jail was opened up for anybody being arrested for a misdemeanor. They were getting out automatically. So it was amazing. It was very unusual. And this is only misdemeanors. It was not dangerous felonies or anything like that. Rosenthal's opinion was described as an extraordinarily thorough, comprehensive, and carefully reasoned memorandum. So right after that injunction went into place, Harris County, I guess as part of the MacArthur grant or part of their earlier program of reforming their bail procedures, put public defenders, and we began working the bail hearings inside the jails, 24 hours a day, 7 days a week. The jail is always staffed with 2 public defenders who have to interview every single person and then represent them to try to get their bond as low as possible. And we started working there on July 31st, 2017. And then just a few weeks after we started working there, and just a few months after that injunction went into place, Hurricane Harvey hit, and the criminal courthouse completely closed and was declared a disaster, and all courts had to be relocated to other buildings. And so this caused a whole lot of confusion amongst everyone in the criminal justice system. No one knew where their court was going to be or when it was going to be. And at the same time, the county was upset that all of these folks were getting out, even though they couldn't pay their bond. And so the county's fighting this lawsuit, paying millions of dollars on their private attorneys to fight against the plaintiff's ideas on bail reform. And so they start, going to the media about how many people are not showing back up for court. And they're like, this federal district judge just opened up the jail to everyone, and it's creating this public hazard, and it's such a dangerous crisis because these folks are not showing back up to court. And so they came up with these statistics saying that 43% of people who were released on these misdemeanors were not coming to court. They were not able to provide the actual data to back up those figures. And there was a lot of things that happened that exacerbated the bond forfeitures. For one thing, everyone who was charged with a misdemeanor was required to come back to court the next business day after being booked into the jail. Okay, so that was like one of the county rules of the county courts. So it was like, okay, so the first setting for everybody on a misdemeanor is going to be 24 hours after being booked in the Harris County jail. Well, guess what? A lot of people didn't even get released within 24 hours of being booked into the jail. So they're being bond forfeited when they haven't even actually been released from jail yet. They're being bond forfeited when they got out of jail at 4 a.m., and then we're supposed to appear in court at 8 a.m. And so we had a lot of people sleeping on the sidewalks, or, coming to court in, clothes that were tattered and dirty, or saying, I can't go to court looking like this. There is a dress code. I mean, the courts don't even allow you to come in with if you're wearing shorts. But you haven't even had time to go home and take a shower. You haven't slept in a day and a half. You've been sitting on concrete benches, and they're bond forfeiting you when you don't show up to that first setting. So the numbers were exacerbated by a lot of things. And the county wasn't giving good information about where they were supposed to appear in court since the criminal courthouse was closed. People didn't know where to go. They were still having these written orders saying, you have to appear in the criminal courthouse on such and such a date. Well, and then you show up to the criminal courthouse and it's closed, so you don't know where to go. So there was just incredible confusion. And there was a lot of media reports about what a dangerous situation we have because all of these people are just being released and then not showing up. And, the system would collapse if we didn't follow money bail. All right, so Harvey happened in August of 2017, and then a few months after that, in February of 2018, the Fifth Circuit came out with an opinion affirming, in most part, the preliminary injunction and all of the findings of Federal District Court Lee Rosenthal. And so this, the O'Donnell versus Harris County Fifth Circuit opinion is very important, and it could have a lot of effects all around the country because that is the Fifth Circuit saying that Harris County's bond procedures were unconstitutional, violated due process, violated equal protection. The Fifth Circuit said, in sum, the essence of the district court's equal protection analysis can be boiled down to the following. Take two misdemeanor arrestees who are identical in every way. Same charge, same criminal background, same circumstances, etc., except that one is wealthy and one is indigent. Applying the county's current customs and practices with their lack of individualized assessment and mechanical application of the secured bond schedule, both arrestees would almost certainly receive identical secured bond amounts. One arrestee is able to post bond and the other is not. As a result, the wealthy arrestee is less likely to plead guilty, more likely to receive a shorter sentence or to be acquitted, and less likely to bear the social costs of incarceration. The poor arrestee, by contrast, must bear the brunt of all of these. Now, right before the Fifth Circuit opinion came out, another truly unusual and remarkable thing happened. That grievance that was filed against the criminal hearing officers, against the magistrates who were being so abusive to the pretrial detainees, the grievance was sustained. And so they were actually disciplined by the state Commission on Judicial Conduct. The State Commission on Judicial Conduct decided that the magistrates had failed to follow the law by not using individual discretion in granting personal bonds, that they were just abandoning their judicial powers and judicial responsibility by just they were abandoning their responsibility to use their judicial discretion by performing blanket denials of personal bond without any consideration of the individual's circumstances. Now, when that grievance was being litigated, the magistrates, who, as you will recall, are being sued in federal court for not granting personal bonds, blame the county and district judges, who are also being sued in federal court for not granting personal bonds. So the magistrates actually put into evidence all of these documents showing that they were ordered to deny personal bonds by the county judges, by the felony judges, and, just completely passing the blame to them, which totally incriminates the county judges in their own lawsuit where they're being sued in federal court. And so it proves that the higher judges are threatening these magistrates, saying, if you don't deny these personal bonds, if you don't set these bonds the way we want them, we're going to fire you. And so the magistrates were like, it's not our fault. We were at-will employees. They were going to fire us if we didn't just deny these personal bonds. So these documents come out showing that it was the county and district courts who were ordering people to be held. And the Chronicle, our reporters go and interview the judges and say, hey, how come you were, ordering everybody to be held without a personal bond? And one of our judges made these comments that got national news where he said, quote, the young black men, and it's primarily young black men rather than young black women, charged with felony offenses, they're not getting good advice from their parents. Why? Who do they get advice from? Ragtag organizations like Black Lives Matter, which tell you resist police, which is the worst thing in the world you could tell a young black man. They teach contempt for the police, for the whole justice system. So that was one of our felony court judges' explanation, talking about why he instructed the magistrates not to grant personal bonds. In another odd turn of events that's very befitting of Harris County, after those magistrates were found to be in violation of the law and disciplined by the conduct committee, what do? They turn around and sue the Judicial Conduct Committee for disciplining them. So now they have a separate lawsuit against the Judicial Conduct Commission, and a state agency, arguing that it somehow violated the magistrates' rights to be disciplined in this grievance hearing. So right now, as I speak, the O'Donnell case is moving towards trial. The county refuses to settle. Depositions are being held. Millions upon millions of taxpayer dollars are being spent resisting bail reform by Harris County. And so O'Donnell versus Harris County has the potential to change things all over the country. There are inroads currently being made, moving away from cash bail. It was just declared unconstitutional in California. Things could go the same way in Texas. Other lawsuits are being filed. It's a very bizarre situation, and I can't wait to see what happens next.